My lord, one meter, my lord, selection and upon armed force, my lord. A meter was fixed, my lord, but not existed. So 8 May.
May I please, your lordship.
Okay.
I beg to mention item number 15 on behalf of Mr. A. Daga, your lordship. His uncle had expired, he has to leave for Sonari. He is for respondent number 4. Is a hearing matter, your lordship. Can it be come in the next week, your lordship? Or it may be further.
Who you have informed the other side?
Yes,
Yes or no?
no.
Then-
Here, I have been informed today morning, your lordship.
That's right, but you must inform the other side.
Yes. Mr.
Petitioner-
S. colleague is there, he is not here.
Inform him, then we'll see.
Yeah.
First inform him. Yes.
May it please your lordship, I beg for listing of a date petition for Friday, your lordship, 28th of this month.
Listing for what?
For the Labour Commissioner has
Listing for what?
date petition motion, your lordship.
What is the urgency?
Urgency is that the Labour Commissioner has asked us to pay the salary of a retired employee for the period which he has not worked for. Highly obliged.
For motion item 1.
May I please, your lordship? Your lordship, on last occasion, your lordship, we were directed to bring instruction, your lordship. Unfortunately, it could not be done, your lordship.
Why?
Some 10 days, your lordship,
Why unfortunately?
your lordship,
What is the misfortune here?
misfortune, your lordship, on my part, one part.
Ah,
Due to the vacation, I was.
you're enjoying Bihu.
I'm extremely sorry.
Mr. D. Hussain,
My lord.
Learned Counsel for Petitioner is present. Mr. K. Kumar, Learned Additional AG Assam, submits that due to some personal difficulty, the instructions as called for by this court could not be obtained. He, therefore, 6, posting of this matter for motion again in the next week, so as to enable him to obtain his
Your lordship, 10 days time may be given. your lordship.
posting of this matter again after 10 days for obtaining instruction. Prayer allowed, list this case accordingly.
Highly obliged.
May it please, your lordship. In this case, my lord, and on behalf of the APSC, my lord, they paid for a declaration of the result. So I received the instruction, my lord, there are another 5 writ petition are pending. In those cases, my lord, there is an interim order operating stating that the 92 posts may be kept vacant because there are 5 writ petition. So total posts advertised 307. So if 92 posts, my lord, kept vacant, my lord, then my lord, roster position will be.
Give me the number of those.
Yes,
cases.
my lord. Number, my lord, these are number and this is the instruction.
We'll have all those.
Yes,
listed
my lord,
next.
correct, exactly. That is my PR, my lord. Otherwise, my lord, it will be complicated arise, my lord.
Yes. I heard Mr. B.P. Bora, Learned Counsel for the petitioner, also heard Mr. T.J. Mohanto, Learned Senate Counsel, assisted by Ms. B. Bora, B. Sharma.
P. Sharma.
P. Sharma, who submits an instruction that the results of the test held by the APSC could not be declared due to interim orders operating in WPC numbers so and so, which are pending before this court. Full stop. Mr. P. Nayak, Learned
Standing Council PW 1, 2, 3, and 4.
and Standing Council PWD is present on behalf of respondent number 1, 2, 3, and 4. And Mr. You are also there? Mr. Fukan, in this matter, no. In view of the prayer made by the Learned Counsel for the respondent, register to list this case along with WPC number so and so, again after 10 days.
My lord, in those cases, we have already filed a affidavit.
Yes, who is for the health department? Standing Council Health. Yes, Mr. Bora, do you know? Are you aware of this case?
Yes,
Why
my lord.
NOC has been rejected?
Yes, my
He
lord.
wants to participate in a recruitment process.
No, my lord, I have already been selected and
Yes,
I have
sir.
asked to join. There is a rule, my lord, and in this case, my lord, that particular rule has also been challenged, my lord. Your lordship may
What is the
pay
rule?
My lord, your lordship will find that.
base 50, my lord. So they have challenged the rule also, my lord.
At page 50 is the relevant portion.
50, my lord.
Yes,
Clause 11, 11, sub clause 11, my lord. the acceptance of the no objection certificate for applying to any post, be it directly under central government or any state government or any other organization, oblique authority established by the central or state government or any other organization shall be considered only if patient care or academic services at such institute oblique college where a member of service is so serving are not affected and shall be dependent upon the need of the larger public interest.
Yeah, so how, what has that got to do with this?
Because in this department, my lord, so accordingly,
So this is
the,
about acceptance of no objection certificate.
yes,
You are
my-
not to accept, you are to issue.
yes, my lord.
This is not about issuance.
The same issue, my lord, acceptance of, because they are not issuing. Because in terms of this, if your lordship sees,
Mr. Bora, read the language of the rule. It says acceptance of no objection certificate
yes, my lord.
for applying to any post. Yes.
Yes. The no objection certificate has been, because in terms, there may be some, in the interpretation may be something different, my lord, but the purpose of this clause is that, my lord, the no objections, and accordingly, my lord, some departments have been identified where there is scarcity of doctors, my lord. So those departments, my lord, and they have, my lord, if your lordship sees the prayer portion, they have challenged this particular rule also.
This is what, a statutory rule?
Yes, my lord. Yes, my lord. This is a rule, my lord.
Page 46 is the beginning of the rule.
It is the
You also
amendment.
will see in
Original rule is-
earlier cases also when this.
Just a minute, just a minute. Oh, this is under proviso to Article 309.
Yes,
It
my
has to
lord.
go to DB, Mr.
Division bench, my lord. Yes, my lord.
You have challenged the rules.
Yes, my
Yes,
lord.
but problem is, my lord, that tomorrow is my joining date. Till that, my lord,
Nothing can be done. These matters have to be listed before DB.
Yes, my lord.
so your lordship will directly register to place it before the
Yes.
listed division bench tomorrow. Man.
Had Mr. B.D. Paul, learned senior counsel appearing for the writ petition, also had Mr. D.P. Bora, learned standing counsel, Health Department, Assam, who submits that since rules framed under proviso to Article 309 of the Constitution of India is under challenge in this writ petition, the matter would lie
This
before the
is the
division
beginning.
bench. Mr. Kuar has not disputed the.
My lord, may I propose, my lord? At this moment, my lord, if we don't challenge we'll withdraw the prayer to the rule. If our right is protected, my lord, we may withdraw the challenge to the rule, my lord.
Mr. Kuar, these things can't be done orally in this manner. You are saying, give me the relief, I will not challenge the.
No,
rule.
my
That's
lord,
what it
my
is.
lord, if third party right is not created, my lord,
If
then,
you don't challenge the rule, then only notice can be issued.
my lord, but your lordship will protect the post because that post, if it is filled up by the wait list candidate.
No, it is a DB matter, let it
Take it,
go to the.
take-
Does not dispute the said provision, but submit that since the last date of joining is tomorrow, there is a emergency in the matter. First of, in view of the above, office to verify and list the matter before the appropriate bench tomorrow. That is-
Division bench.
List the, verify an appropriate bench tomorrow, that is, give the date,
Debatable.
in view of the urgency expressed by the petitioner's counsel.
I'm obliged.
Yes.
Obliged, my lord.
For admission, item 3.
Since my lord, the rule has been challenged, my lord, the registry may direct to show the office of the AG because AG's presence will be required when a rule is challenged.
By reflecting the name of learned Advocate General Assam in the cause list.
Item 3.
Is there client is here? And these are the original documents for which he Khatrapal is there. Are you correct? Okay. I'm sorry.
What is this?
These are the original documents of his.
Yeah, we can't, original of documents annexed here.
No, not all of them. Their PAN card and everything that even ONGC certificates are of the Khatrapal.
But
That-
these have to be brought on record by an affidavit. We can't look at document and pass orders.
No, you want to see him that because just to substantiate it, that he's Khatrapal. Because these documents are there, some documents are there, Khatrapal.
Actually, just a minute.
PAN card and all those things are there, Your Lordship. School certificates are there, that is also originally there. This annexure P8, P9, P8.
What is the name mentioned in the award?
Khetrapal. It is a page, I just give the page number also.
And why the Bauri name has come?
Bauri, they use the same title. Bauri and Khetrapal are same community. Interchange, they use it actually. Your lordship see at the list says at page
45.
45 Khetrapal. It's with the award, your lordship. Even gate passes are also the BS Khetrapal. Ranges.
So according to you, BS Khetrapal and BS Bauri
It's the same person.
is the same person.
Yes, your lordship.
So let him come. What is your name? Inam.
Yes, Khetrapal.
Father's name?
Ramlal Khetrapal.
M.R. Khetrapal.
Ramlal.
Where is your house? Gharkot.
Sipsagar.
He understands Assamese.
Yeah, sorry, sir.
Gharkot.
Lakwa. Sipsagar.
Lakwa Sipsagar. কেতিয়া জয়েন কৰিছিলে অইল ইন্ডিয়া ONGC কোন বছৰ
86.
86 Mr. Chakravarti,
My lordship has seen the name appearing in the order of reference B.S. Khetrapal, who read up to class 10 and was working from 1486. Now, my lord may come to page 100. It is a certificate issued by Pathaligarh High School, headmaster of Pathaligarh High School. It says that B.S. Khetrapal, son of so-and-so, left the school on 15/4/1987 and his age was while he was reading in class 10. So, my lord,
Mr. Chaudhary, where is the statement when he joined service?
It is here, Your Lordship.
Para number?
I guess. Your Lordship will see. Your Lordship, para 21, page 20.
Para 21.
Yes, page 20. List of days also it is there. Even a list of date page, first page. also. Roman 8. Para 23 also said para 20, all the pages, 20 and 22, 23, all has stated the same thing.
Otherwise, the award has been implemented in respect of others.
Yes, Your Lordship.
His case, the award was not implemented
Your Lordship.
only because of
This Ketrapal.
Now, my lord, once the award attained finality after the judgment of the apex court, everyone named in the reference were given the opportunity to establish their identity. Now, this man, first, he approaches ONGC with an affidavit that his actual name is B.S. Bowdy, which your lordship will find.
who else is claiming this benefit under the award?
No one is claiming. He has claimed saying that his name is B.S. Bowdy. He gave his PAN card. He gave one school certificate in the name of Ketrapal, voter ID in the name of Bowdy. Now, my lord, then he was asked to clarify. Now, this man has produced before ONGC 3 PAN cards, my lord. One in the name of B.S. Ketrapal, spelling B-E-Y-E-S. Ketrapal, another in the name of B-I-Y-E-S Ketrapal, another in the name of B.S. Bowdy. All the 3 PAN cards are active. Now, my lord, he gets a certificate issued from the headmaster Pathaligarh High School showing that his name is B.S. Ketrapal and he left the school on 15/4/87 while reading in class 10. When he was pointed out that the name is something, his name is B.S. Bowdy, then he got another certificate issued from the same school in the name of B.S. Bowry. And
The award is dated 18/12/2000
Yes, Your Lordship.
and it has not been
No,
implemented.
312, actually, just 312, 2000.
3/12.
my lord, this award was of 2000 because of the round of litigation. It attained finality very recently, my lord.
Not recently, it is 2000, not recently, 2000, 3 years, 4 years back.
Yes, 3 years, 4 years, it is
Not 3 years, it's not a recent, 4 years cannot be recent.
the last order by which
Your Lordship will see on the skill development center certificate which are given to ONGC in 2008, that's category, it says Ketrapal and his photograph is there. The original is there, Your Lordship. See. That is issued in 2022, Your Lordship.
And my lord, in the writ petition, they are praying for your lordships to issue a direction that to carry out the exercise and issue a direction that B.S. Khetrapal and B.S. Bowry is one and the same person. My lord, our stand in the affidavit that this is an exercise which your lordship under 226 cannot carry out, my lord, or may not be.
We'll do it
My
today.
lord, my lord, may I record my submission, that is the stand of the department, that it involves question of fact, and more so, my lord, the B.S. Bowry or B.S. Khetrapal, whoever the certificate is before your lordship, he was in the school and left school on 15/4/87 while in class 10. And the reference says the man who was connected with the reference was in employment on 1/4/86. So, and the age of this man, as per the voter ID card or PAN card, is 8/10/70. So in 86, he was less than 18 years. So the man who was connected with the reference and this man is not the same person.
Have you raised this issue before the tribunal? No.
My lord, this exercise was not there. Tribunal
So
exam.
you are saying that if this man Khetrapal is the person in the award,
Yes,
then you don't have any objection.
yes,
But according to you, he is not the person.
yes, because
is
of
the
this
person?
discrepancy.
Who is the person in your role? Produce him. Who is the other? Somebody is the Khetrapal, na? Somebody called B.S. Khetrapal is your employee. He is all along claiming he is one. He has produced this I-card issued by the ONGC, etc., other documents. Now you are saying Khetrapal is entitled to award.
And
But
he is
he is
saying
not
his
the
name is
Khetrapal.
B.S. Bowry.
Who is the one? We don't know.
Lordship may have a look at the affidavit. He is saying his name is B.S. Bowry.
Yes, it can be there explaining it. These are communities or names.
And they are seeking a declaration from your lordship that Bowry community and Khetrapal is the same.
These are his original cards. Have a look at it. Are these fake documents?
My lord may
Some
also see
school
that,
headmaster making some observation. in
Even
the
skill
certificate.
development center, their card.
my lord, headmaster has given 2 certificates. One in the name of B.S.
Go
Khetrapal.
and catch hold of the headmaster. There are other documents also. These are harassment. If there was somebody else coming and claiming, then we understand it.
My lord,
Who is, have a look at this. There are more documents here. These are originals.
these are not the things which is there in the writ petition, my lord. I have to, yes, I-cards and all.
PAN cards are there, PAN cards are there.
Why so many original I-cards of same?
Because they're time to time they give. Period to period.
And my lord, 3 PAN cards, my lord, a person cannot have 3 PAN cards. If one person is one and the same person,
Mr. Chakravarti, when you make a submission before.
But
the
he is
court,
making deduction. on
Just a
3%.
minute,
Yes, sir.
please apply your mind. The issue here is not whether there can be 3 PAN cards. The issue here is not whether the principal is right in reflecting this. The issue here is the award passed by the tribunal names a person called B.S.
B.S. Khetrapal.
Khetrapal. You have implemented the award. The benefit of the award must go to the person called B.S. Khetrapal as well. He comes to the court saying that I am the B.S. Khetrapal. My name alias is B.S. Bowri. So why are they not giving me the benefit? He comes to the court, produces original documents. You don't dispute that there is a B.S. Khetrapal. You don't say that anybody else has claimed this benefit of the award as B.S. Khetrapal, but merely because you don't find some document in order, how can you question his identity now?
No,
Have
my
you
lord.
lost any, have you initiated any proceeding?
No, my lord.
Then-
What I'd like to submit before lordship is, when the time for implementation of the award came and notice was given to everyone to establish your identity, this man comes with certain documents showing discrepancies.
Hmm.
We asked them to clarify it. Then he brings some more documents, which creates more doubt. Now, my lord, may I appreciate one thing. It may so happen that he is the same B.S. Khetrapal, or maybe that original B.S. Khetrapal who worked is no more, but someone is coming to take place. So, my lord, it requires an exercise of examining the disputed question of facts. Because, my lord, the certificate is very clear. School certificate says that B.S. Khetrapal left school on 15/4/1987 while he was in class 10. And the man B.S. Khetrapal, who is named in the reference, was already in employment on 1/4/86.
Mr. Chakravarti, if you say that he is not Khetrapal, he is not the B.S. Khetrapal who was employed with you. That is a positive assertion made by the ONGC. You have to then come up with the materials from your side. You can't depend, based on his document, you can't raise a doubt about his identity. Because he is the one who is relying upon this document. These documents may have some discrepancy here and there. But the question is, we are not on the question of discrepancy or correctness of the document. We are on the question as to whether anybody else other than him is a B.S. Khetrapal. He has produced original documents prima facie to show that he was in the role of employment of the ONGC. These original documents are there. What you want the court to send him to civil court to try it
No,
for
my
another 15
There is a procedure in the Industrial Disputes Act, because the reference was decided by the industrial tribunal or the labor court. They will carry out an exercise as to how, whether this B.S. Khetrapal and the man who is before this court is the same person.
Anything else you want to add?
And my lord may record my submission that he was in class 10 in 2087. So he could not have been in employment in 1/4/86 because his date of birth shows that he was less than 18 years.
Then who was in employment? You produce
May-
that person.
If that person has already died, we do not know.
You give the particulars of that person. Who was that person, B.S. Khetrapal, who was in your employment? What is his
My
father's
lord,
name?
they were working under contractors.
Hmm.
They were contractors' employee.
Hmm.
That is the dispute which ultimately,
Forget the contractor, Mr. Chakravarti. This is a proceeding in a 226 court.
yes.
You have to come and show us that, see, this is the person B.S. Khetrapal who was there. He is not the man. And this is further supported from the discrepancy in his document. Otherwise, how is, he is a person who is seeking benefit of an award. You never raised these issues before the tribunal.
My lord, in the tribunal, the persons who are connected with the reference credentials were not examined. The only question that was examined in the tribunal is whether the persons named in all these references were in employment under James ONGC and whether they are entitled to be regularized.
Correct. So
So-
B.S. Khetrapal was also in the employment order.
Yes,
That you accepted.
yes.
Now, who is the other B.S. Khetrapal? You have to produce it before him, his documents before the court. To say that
Because
he is not
his
in the-
document shows that he is not the same B.S. Khetrapal because he is having different identity cards, different PAN cards, voters card every time.
Different from whom? From the original one.
No, he comes with this PAN card saying, I am B.S. Gaurav. That is why I'd like to take your lordship to this.
You, Mr. Chakravarti, unless you give us documents to show that there is another person with different credentials who was the B.S. Khetrapal in office and raise a dispute on his identity, we are going to close this matter today. Just because you don't think it is okay, that doesn't make it a disputed question of fact. You have to make it a disputed question of fact by leading prima facie material to show that there are two sets of documents which proposes a contrary theory. Not because of his document where there is some discrepancy. That is not disputed question. First of all, you must be very clear on that. That is not a disputed question of fact. A disputed question of fact is when he makes an assertion on his own document and you produce contrarian material to show that this is not the man, but look here, these documents prima facie shows that there is another person by the name of Khetrapal who was the actual employee. What you are saying is, oh, he has produced 10 documents, out of which this I like, this I don't like. So there is
No,
a
it is
dispute about
not,
it.
my lord,
That can't be
whether
the
we
way.
like or we do not like. We are saying that you have produced a school certificate saying that you are in the school in 1987 and you left the school on 15/4/1987. On the contrary, the record of the reference shows that the B.S. Khetrapal, who was connected with that reference, was already in employment on 1/4/86. So this document, school certificate and the materials of reference gives a picture that these two persons may not be the same person. That is why
May
we
not
asked,
be or maybe also.
maybe, may not be.
So that it is now for him to go and establish in some proceeding that he
Because,
is-
my lord, if you are trying to claim benefit of an award, is it not his responsibility to come with all materials to clearly establish that, yes, he is the person who is connected with that reference? And my lord, a person working already in employment in 86 cannot be a student in a school. Another aspect, my lord, the school headmaster issues two certificates, one in the name of B.S. Khetrapal, another in the name of B.S. Bowri, showing everything. The school register must contain only one name, my lord. It must contain one name with the particulars of his living in the school.
Mr. Chakraborty, on a lighter vein,
My lord.
to dilute this situation a bit. These arguments and contentions coming before the court today reminds me of a literary work of a very, I don't know whether you have ever read Bankim Chandra Chattopadhyay. There is a prose called Kadambari. So somebody may be aware. The person who was alive, everybody said, no, this person has died. So that person was so frustrated that ultimately he had to die to prove that he was alive when his claim was there. Are you suggesting something like
No, my
that?
lord, it is not. My lord, what I am saying it from the record. These documents creates a discrepancy which can lead to a situation where if one concludes that they are not the same person, then it will not amount to an irrational conclusion. So, and another thing, they have approached this honorable court for a writ of declaration. Normally, a process of declaration is the
That's right.
thing which is to be done by a civil court. So, my lord, under 226, first time I am coming across such a case where your lordship is called upon to issue a writ of declaration, declaring that Mr. X and Y is one and the same person. Then, other thing. Then, to another declaration that Bowri community and community is XT type community. So, my lord, my submission is these are the materials to show that this person who is before a lordship may not be the person who was connected with the reference, and a person cannot have 3 PAN cards in 3 different names. Lordship will examine this aspect that his first PAN card, which he submits before the authority, is in the name of B.S. Bowri, B.S. Khetrapal. Then he comes up with another PAN card in the name of B.S. Bowri, and lastly another PAN card, B.S. Khetrapal. And all the 3 PAN cards are active. So one man cannot have more than 3 PAN cards. And if there are more than 1 PAN card,
All 3 PAN cards numbers are different.
yes, but they are active. They are active. Lordship may have a look at the report 128 of our affidavit. This is PAN card number, my lord.
Yes.
This is PAN verification, which was carried out on 14th March 2022. This is a PAN card in the name of BS Khetrapal, CPC PK 61570.
Where is the name here?
My lord, just by the side of
Hmm,
status and name.
yes,
This is BS Khetrapal.
yes.
A verified PAN verification 14th March 22. This is the PAN number, status active.
Hmm,
Next, my lord, will find on the same day, 14th March 2022, PAN verification status active, PAN BS Baudi.
hmm.
Then the third, on the 14th March, this verification was carried out. PAN verification. PAN card number so and so in the name BS Khetrapal. This is also active. So if we have a doubt that one person cannot, it is a question of law, my lord. Under the Income Tax Act, one same person cannot have more than one PAN card. So if a person is having 3 PAN cards in 3 different names and all the PAN cards are active, and on that basis, together with that certificate to show that on 1486 that BS Khetrapal was in employment, whereas this certificate shows that BS Khetrapal is in school. So if we form an opinion that the BS Khetrapal who was connected with the reference and the man who has come before the authority to take benefit of that reference is not one and the same person, then whether it will be a irrational conclusion. My lord. So this, my submission is that 226, a writ of declaration cannot be issued. And that is what we have stated in our affidavit. And these 3 PAN cards showing that they are active. And this amounts to a examination of question of fact. My lord.
Anything else?
No, at least.
Your lordship. ONGC, this TDS, they have detected 3 times. They should have verified it. That means there's someone in employment, BS Bauri also, because it is a deduction made by ONGC, not by anyone.
Well, there is no deduction.
Yeah,
lordship.
your lordship,
See
see,
that. It
ONGC
is not
that-
deduction.
Let
It is
let-
TDS
please,
PAN
please,
verification.
I need
I'm
to-
sure.
Please don't interrupt. Your lordship, see, it is by ONGC who has carried out.
No, see, the point is not there.
Yes,
Is
sir.
it that he has 3 different PAN cards?
Yes, your lordship.
Why, how it is possible?
Your lordship, they, at that point of time, we was having some problem. I don't know actually what had happened that time, because PAN card, your lordship, earlier, your lordship, they have different name, because it was not computerized at that point of time, so they issue it that way, your lordship. So he changed the name, they didn't cancel that thing. So these people are illiterate people, your lordship. For the ONGC, they are deducting from the salary, your lordship. And your lordship will see that school certificate, that's fees payment up to this, school certificate is up to, he has paid fees up to 87, that's why the certificate is still 87 years old. He's a school dropout, your lordship. 87, which my learned friend is relying, it is, if your lordship will see that his fee has been paid up to this thing, if your lordship will see that,
Left the school.
just, their school, these are all by school.
Which page? Which
Yeah, the page 100, your lordship will see.
Mr. Dhar, is it Sharat Chandra or Bankim Chandra? Bankim, yes.
If your lordship will see page 100, if all sums dues paid by have been paid up to 15,487 years, they have taken him to still to learn. But here the school, he got a certificate later on, your lordship. So they, according to payment of fees, they have this certificate issued in 90, your lordship. So they say issued the certificate on the basis of payment of fees, if your lordship will see. 87, your lordship.
And what was the reference whether their services should be regularized?
Yes, your lordship. If your lordship will see page, I'll just.
So what if the award is implemented, then his services
Sir,
will
regularize,
stand
your lordship.
regularized with effect from?
Yes, with effect from the date of your lordship, the award. Yeah. It is, if your lordship say page, it starts at page 41, your lordship will see. The award, page 41. Because these people have been put to litigation for second round in Supreme Court also, Your Lordship. And now still they are going litigation. Page 41, bottom, Your Lordship. From whatever angle is case, I am the opinion so and so, Your Lordship. Contract, under the slow circuit, they can be deprived of the right for regulation in service. These workers are working since 1982 without any break. The project is permanent on, and the works done by these workers are perennial in nature, and they have the requisite qualifying expense for regular. Considering the entire facts and circuit, I am of the opinion that it's a fit case where order of regulation can be passed, according to I do so. In the result, I hereby direct the management to regularize the service of all 69 temporary workmen in their service within a year from the date of the award. 15 workers who have been discharged without adopting the procedure prescribed by law during the pendency of the reference should be re-engaged immediately and be regularized accordingly. If all the workers could not be regularized within a period of 1 year, they should be paid equally based on those regular employees till they have been regularized by adopting formal procedure. Your Lordship.
So he is one of the 60.
Yes, yes, 69, Your Lordship. That is that page, Your Lordship. I'll show it. That list is there, award. The list is that Your Lordship will see page 45, serial number 12.
This is annexed to the.
Yes, I do. Award,
number of
award,
employees in the
award. It's
reference.
award, yes.
All right.
Here it says 143, here also it says that.
But it may not be legal to have 3 PAN cards.
Yeah, that I agree. That I am not disputing that fact, Your Lordship, because these people are khalasi, they are down to it, they may not be knowing the intricacy of this thing, Your Lordship. But OSDC should also taken care. What they are TDS is from 3 accounts. They should have who is that BS customer, who is BS. They should have inquired also. They put the blame on us that it is different person, Your Lordship. That is the burden is also they should have pointed how can you have 3 PAN cards? 1 person.
My lord, it is never a tax deduction. Lordship may have a look at the certificate. This is that something downloaded where they have verified.
Mr. Chakraborty,
it is
you
not tax
you have
deduction,
argued
sir.
your case. You have argued.
It is not, I'm just clarifying one
The
thing.
procedure in the court of law is as a counsel, you can only argue.
Yes,
Man.
yes.
The decision is always of the.
Yes,
judge.
definitely, my lord.
So you made
I'm,
your point.
yes, but I'm just pointing out to your lordship, my friend is saying that it is a TDS
That's
certificate.
right. You made your point.
Yes, that it
You
is not.
said that he is not BS Khetrapal.
No, my
or he
lord,
may
this
not
is
be.
a PAN verification process.
Correct.
It is not tax
I
deduction.
will
certificate.
deal with these arguments.
Right.
I will deal with these arguments. Yes. That's all. Take your seat. Yes. Heard Mr. P. Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr. S. Chakraborty, learned counsel appearing for the respondent numbers 1 and 2. Huh? Okay, respondent number 1, Mr. A. Mubarak, learned counsel is, you want to say anything?
No.
You don't have to say anything. We'll write that you have nothing to say.
They are a member of on this.
So what about this man?
He's the BS Khetrapal.
He was your employee.
No, no, no.
No,
He
no.
is the
a member.
You.
The member.
respondent, my lord, we have also dealt with this. Respondent number 2 is the union of which he is the member. But union did not come up with any case,
So his stand is that
Same.
Yes.
person is
Okay.
the member of the union.
member of the union.
Mr. A. Mubarak, learned counsel appearing for the respondent number 2. Full stop. The writ petitioner herein, namely Sri B.S. Khetrapal, alias B.S. Bauri, claims to have been engaged as a khalasi on 1/4/1986. And since then, he has continued to work as a temporary stroke casual employee under a contractor engaged by the respondent number 1 to carry out certain.
No, our case is not, we are not saying under contractor, we are not saying that. We are saying ONGC, we are under contractor.
Let me write like this. The
That's what the award is also. We are
petitioner claimed that he was engaged as a casual public
contingent worker.
contingent
Worker under the ONGC.
under the respondent number 1 with effect from 1/4/1986. And since then, he has been working as such, full stop. Aggrieved by non-regularization of the services of as many as 69 such casual stroke contingency workers, including the petitioner, an industrial dispute was raised pursuant whereto reference case number 21(C) of 1999 was registered before the Industrial Tribunal, Guwahati at Assam.
Page 7, the reference is there. Page 7 of the paper.
The reference is quoted herein below for ready reference. Page 7, para 3, double tick to double three. Stop. The learned Industrial Tribunal had answered the reference in favor of the workmen by award dated 3/12/2000. First of, the operative part of the award dated 3/12/2000 passed in reference number 21(C) and the connected proceedings is reproduced herein below for ready reference. Page 42, double tick to double tick. Full stop. The award dated 3/12/2000 was assailed by the respondent number 1 before this court, which was turned down, whereafter, SLP was preferred before the honorable.
Division bench होता है. Single judge has dismissed the writ petition. They went to division bench.
Assailed before this court by filing WPC number.
Your lordship is WPC number is it is just WB 8369 of 2001. There are two WPC are there together.
What is the one connected with this?
The other award, there are two awards are there. Then when it came before the honorable court, both the award was challenged and common judgment. After that, both the award common judgment followed, your lordship.
So,
learned single just decide both the awards.
so
together.
he is the case, reference case where he was involved.
Yes, sir.
That was challenged in which WPC?
This one, 8369.
8369
Of
of
2000.
2001,
Yes, sir.
which was dismissed by this court. Full stop. Initially, the writ appellate court had passed an order in writ appeal number
267 of 2004.
267 of 2004.
That was allowed. That was allowed, and the matter was remanded back to the industrial tribunal, your lordship.
Which had allowed the appeal along with the connected writ appeal being 266 of the 2004.
Yes.
With a direction to the learned single judge to reconsider the matter.
No, not learned, sir, tribunal, your lordship, not tribunal.
By the tribunal.
Tribunal, your lordship. Because they said seal authority judgment, that was seal judgment was
By
not.
setting aside the order of the learned single judge.
Yes, sir.
Full stop. However, agreed with the order of the division bench dated 2/2012.
It is page 76 division bench order is
The
there.
workmen had preferred special leave petition
Yes, sir.
hearing SLP number 23494/2000
12.
2012
Yes, your lordship.
before the Honorable Supreme Court, which was allowed by the order dated 3/4/2018. And the matter was remanded back to the division bench for a fresh decision.
No, on your lordship, they pleaded that certain issues have not been decided because the division bench did not express anything on merit.
We'll pass the order in the chamber.
Yeah, order is here, yeah. Your lordship, see page 76.
Mr. Chaudhary, are you aware there is already an order of this court?
Yeah, I know. Your lordship judgment.
That's the same thing. I'm
Yes, the
repeating
same
it.
thing, because that is the other award.
No, am I bound to write on what grounds the SLP was raised?
No, I just, because I'm just clarifying.
SLP was allowed and matter was
Yes, sir,
remanded.
that's
That's
fine, that's fine.
Matter was remanded for a fresh decision by the division bench. Full stop. Consequent to the judgment, consequent to the order dated 3/4/2018 passed by the Supreme Court. The two reticles being WA number 266/2004 and WA number 267/2005 were heard afresh, and both the appeals were dismissed by affirming the judgment and order passed by the learned single judge in WPC numbers 8376/2001 and WPC number 8369/2001. Consequently, the award dated 3/12/2000 had attained finality. Full stop. When the award was not implemented, several aggrieved workmen and of their family members had approached this court by filing writ petition bearing WPC number 8802/2019, seeking implementation of the award. Full stop. This court, wide order dated 9/2/2023 had allowed the writ petition with a direction upon the respondents to implement the award in a time-bound manner by spelling out the consequences in default thereof. Full stop. It appears that in terms of it has been implemented in case of others, is it?
Well,
It appears that in terms of the order dated, no, it appears now, Mr. Chakravarti, learned counsel for the respondent number 1 submits that pursuant to the order dated 9/2/2023 passed by this court in WPC number 8802/2019, the award has been implemented.
my lord, if I'm not wrong, this case related to person who already expired. It is the legal heirs who were before your lordship. So before this order, my lord, others were appointed.
With regard to the petitioners in WPC, in the said writ petition, whereas in respect of other categories of workmen, the awards were implemented.
Before the writ petition.
Even prior to that. Full stop. However, it is the undisputed question of fact that although the name of the writ petitioner hearing was included amongst the list of casual workers in connection with reference case number 21 of 1999. He has not been given the benefit of the award till today. Full stop. Under the circumstances, the instant writ petition has been filed seeking the benefit of the award. The sole reason for not doing so appears to be a dispute raised by the respondent number 1 as regards to the true identity of the petitioner. Full stop. The dispute, as aforesaid, is primarily raised on the ground that the writ petitioner has produced 2 sets of documents wherein his name has been recorded as B.S. Khetrapal in one set of document, whereas in the other set of document, the name has been shown as B.S. Bowri. Full stop. Aggrieved thereby, the petitioner has approached before this court by filing the instant writ petition. Full stop. After hearing the submissions advanced by learned counsel for both the sides, this court had passed order dated 16/3/2023, directing the petitioner to produce original documents in support of his claim that B.S. Khetrapal, alias B.S. Bowri, was one and the same person. The respondent number 1 was also directed to verify and appraise this court as to whether there was any other person by the name of B.S. Khetrapal, alias B.S. Bowri, who was working either directly or indirectly under the respondent number 1 during the relevant period of time. First up, the writ petitioner was also directed to appear personally along with his credentials to answer the queries of the court. Accordingly, today when the matter is called up, the writ petitioner has appeared personally and produced the original documents of the ICARs issued by the ONGC from time to time, as well as other documents to show that B.S. Khetrapal alias B.S. Bauri, son of Rampal Khetrapal, alias Rampal Bauri, is one and the same person. First up, by referring to the documents available on record,
It's Ramlal here.
Ramlal Khetrapal. Referring to the documents on record, Mr. Chaudhary submits that the name of the petitioner is B.S. Khetrapal, but the name B.S. Bauri has been used at times since that was the community surname of the petitioner. Full stop. According to Mr. Chaudhary, the petitioner is an illiterate person who is a school dropout at the level of class 10, and therefore he was not cognizant of the implications of such use of community surname in the official documents. First up, Mr. Chaudhary further submits that there is not even an iota of material to raise a genuine dispute as regards the identity of the petitioner as the person who was employed under the respondent number 1 with effect from 1/4/1986. But the dispute sought to be raised by the ONGC is only to deprive the petitioner of the benefits flowing to him under the award dated 3/12/2000. Mr. Chakraborty, learned counsel for the respondent number 1, on the other hand, submits that the petitioner has produced 3 different PAN cards with the names B.S. Khetrapal and B.S. Bauri before the authorities. Moreover, although he claims to have been engaged as a Khalasi under the respondent number 1 with effect from 1/4/1986, yet his certificate issued by the school headmaster goes to show that the petitioner was in the school till the year 1987. As such, the writ petitioner, who was still a student in a school till the year 1987, could not have been engaged as a Khalasi under the respondent number 1 on 1/4/1986. By referring to such contradictory materials produced by the petitioner, Mr. Chakraborty submits that there is a genuine possibility that the writ petitioner may not be the B.S. Khetrapal who was originally engaged as a Khalasi under the ONGC. And since these documents raise an element of doubt as regards the true identity of the petitioner, there are disputed questions of facts involved in this matter, which cannot be decided in a writ petition. According to Mr. Chakraborty, the writ court can also not issue a direction, cannot issue a declaration by declaration to the effect that the petitioner belongs to any particular community, or that he is the person who was employed as a Khalasi under the ONGC. As such,
Declaration that B.S. Khetrapal and B.S. Bauri is not one and the same.
declaration that B.S. Khetrapal and B.S. Bauri are one and the same person. Such being the position, the respondent number 1 would not act on the award dated 3/12/2000 insofar as the claim of the writ petitioner is concerned. Mr. Chakraborty, to conclude his arguments, Mr. Chakraborty submits that this matter be remanded to the civil court, as the same involves several disputed questions of facts. That's all. Mr. A. Mubarak, learned counsel appearing for the respondent number 2, submits that save and accept confirming that the writ petitioner is a member of the respondent number 2 union. He has no further submissions to make in this matter. Full stop. In reply, Mr. Chaudhary submits that the certificate issued by the school headmaster merely indicates the period to which the petitioner has paid fees in the school and does not in any way certify that the petitioner was actually attending classes in the year 1987.
He was a school dropout.
Full stop. As a matter of fact, submits Mr. Chaudhary, the petitioner is a school dropout, and therefore the certificate issued by the school authorities does not in any way raise any element of doubt as regards the claim of the petitioner of being engaged as a khalasi under the respond number 1 with effect from 1/4/1986. Full stop. Insofar as the production of multiple PAN card is concerned, Mr. Chaudhary submits that whether or not that is a recourse permissible under law is not the subject matter of this writ petition, and therefore he would have no objection if appropriate action as may be permissible under the law is taken in the matter. Full stop. Next, I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record as well as the original documents, including the identity card, PAN card, including the photo identity cards, PAN card, bank passport certificate, etc. produced by the petitioner. Full stop. A perusal of those original documents leaves no manner of doubt that B.S. Khetrapal and B.S. Bauri are one and the same person, and the writ petitioner present before this court in person today is the same person. Full stop. In other words, there is no element of doubt in this case that B.S. Khetrapal alias B.S. Bauri is one and the son of Ramlal Khetrapal alias Ramlal Bauri, resident of Lakwa village, Rangagora in the district of Sibsagar, Assam, is one and the same person, and he is personally present before this court today in support of his claim. Full stop. Therefore, the aforesaid issue is answered accordingly. Full stop. Insofar as the plea of Mr. Chakravarti that there are several disputed questions of facts involved in this writ petition, which requires to be adjudicated by the civil court, I am unable to accept the said contention of the learned counsel of the respondent number 1 for the following reasons. Full stop. Firstly, the respondent number 1 has never raised any dispute with regard to the fact that a person called Ramlal Khetrapal, son of Ramlal Khetrapal,
Ramlal Khetrapal is a son, father.
That's right,
Yes.
son of
Father,
Ramlal
yes,
Khetrapal,
Ramlal.
a resident of village Lakwa in the district of Sibasagar, was one of the 69 workmen whose case was under consideration in reference case number 21C/1999. Full stop. I also find from the record that the name of the writ petitioner finds place in serial number 12 of the list of workmen whose cases were considered by the award dated 3/12/1999. Full stop. Secondly, although the respondent number 1 was given opportunity to verify and come up with particular and place particulars before this court to show that there was another person by the name of Ramlal Khetrapal who was working under the respondent number 1 in the same period of time, no such particulars have been placed before this court today. Mr. Chakravarti has also fairly submitted that no other person has come up with any claim under the award in the name of Ramlal Khetrapal.
B.S. Khetrapal.
In the name of Ramlal Khetrapal or B.S. Khetrapal. All right, let me dictate the judgment. I think I can do it a little better. Yes, B.S. Khetrapal. As noted above, the only objection of the respondent number one is pertaining to the discrepancy projected by the school certificate issued by the principal, showing that the person by the name of B.S. Khetrapal was in the school during the year 1987, and the production of 3 different PAN cards by the person named B.S. Khetrapal, alias B.S. Bauri. First up. These, first up. Insofar as the school certificate is concerned, Mr. Chaudhary has already clarified the matter, and this court does not find any justifiable ground to discard his argument. First of all, coming to the multiple PAN cards produced by the petitioner, if that is impermissible under the law, then law will take its own course, and the respondent number one would be at liberty to initiate action in the matter if so advised. However, merely because such discrepancy has emerged from the documents relied upon by the petitioner, that by itself does not give rise to a disputed question of fact as regards the true identity of the petitioner. First up, the respondent number one has not been able to produce any material to raise a genuine dispute as regards the identity of the petitioner, so as to term it as a disputed question of fact. Therefore, this court is of the opinion that there is no disputed question of fact involved in this case, which requires the matter to be referred to the civil court. First up, under the circumstances, if this writ petition is not entertained, despite there being an award in favor of the petitioner, it would lead to travesty of justice. More so when the award has already been implemented in respect of other similarly situated workmen. First up, for the reasons stated herein above, this writ petition is found to be for the reasons stated herein above, this writ petition stands allowed. The respondent number one would now be required to implement the award within a period of 90 days, implement the award for the writ petitioner within a period of 90 days from today, failing which the financial benefits accruing to him under the award will carry interest at the rate of 12% per annum from the date of the award till disbursement. Look at the original documents. Mr. Chakraborty, you tried, but we had to do our duty.
Lord, it is always
Tell them,
trial and
these are
error.
not good things. You see, just because your client knew what they are doing, your client knew he was a genuine person. It was just a testing thing that put it to the judge and let us see what he does.
Nowadays,
This kind of, see the amount of time it has consumed
my lord,
for nothing. Another many important cases could have been decided. Your clients knew he was B.S. Khetrapal. But despite that, this stand was taken only to see that we will throw our arguments and let the judge decide. These kind of litigations in these matters are not a good idea. Tell your client. Add one more line. Mr. Mubarak has also confirmed that the petitioner, Mr. Mubarak, learned counsel for the respondent number two, has also confirmed that it is the writ petitioner present before this court who is the member of the respondent number two union. If that be so, there can be no doubt or dispute about the true identity of the petitioner in this case. There is no disputed question of fact. Yes.
nowadays, because of the live stream, our jobs have become easier. my lord.
Jobs have become easier.
Yes. They are aware what is happening inside the court. The
They know what is
department,
happening.
They know what is
So
happening.
you are happy. That's good.
My lord, I'm sorry, that was not Bonki, my lord, Tagore. Jivito Amrito, my lord, I just confirm, my lord.
All right, then I stand corrected. R.N. Tagore.
Item 4.
His father died on Mulot 6/12/15. And he applied on Mulot 11/12/2015. But till then, Mulot, the matter is not placed before the DLC. So my limited prayer, my lord, let it be placed before the DLC for taking appropriate decision, my lord.
2015.
Entire allegation is in this case that his case was not placed by the concerned authority. That is not the correct position, my lord. His case was placed, considered by the DLC and rejected, my lord. With the instruction I have received.
Do you have a copy of it?
Yes.
Are you
instruction.
aware of this?
No, not, my lord. I am not.
But he has reiterated, my lord, in 3 paragraphs that his case has not considered, has not placed. A minute.
Let us see what is the ground.
3 minus C has an X, but this minus C has not an X.
Then my lord, we have to select this, my lord. My lord, let them furnish the minutes, my lord.
Can you give him a copy of
Yes,
this?
no problem. I
Then
can-
we'll close it. You have to file a fresh petition. I heard Mr. M. Mondal and counsel for the petition. His writ petition has been filed, primarily aggrieved.
And I am for all the respondents and he will do it.
In this writ petition, the petitioner is primarily aggrieved by the fact that his application submitted on 11/12/2015 for appointment on compassionate ground pursuant to the untimely demise of his father late Abdul Rahman Pradhani on 6/12/2015 while serving as a sub-engineer under the Water Resources Division, Dhubri, has not been considered by the DLC of Dhubri till today. First of all, Mr. B. Goswami, learned additional AG Assam, assisted by Mr. P. Kotaki, has appeared, as well as Mr. D. Bora, learned Government Advocate Assam,
For all the
has appeared for all the respondents and has produced a copy of the minutes dated 11/1/2016 of the DLC, Dhubri, to project that the case of the petitioner was considered and rejected by the DLC on the grounds mentioned therein. First up, therefore, submits Mr. Goswami, the case projected in the writ petition is incorrect. First up, at this stage, first up, Mr. Mondal also submits that, no, you're right, Mr. Mondal, however, submits that his client was not aware of the resolution dated so and so. And therefore, he be granted leave to challenge the aforesaid resolution after a copy is served upon him. Mr. Goswami has undertaken to furnish a copy of the resolution dated so and so, that is the date. Resolution dated 1/2/2016 to Mr. Mondal during the course of the day. In view of the above, these writ petition stands disposed of as not maintainable in view of the resolution dated 1/2/2016. First of the petitioner would, however, be at liberty to assail the resolution dated so by filing a fresh writ petition if so advised.
Obliged.
My lord, she has informed me today that the bank has credited the amount to my client's account, but I have to take that instruction. I do not have. Lordship may fix this matter next week. I'll get back to your lordship if.
Right, Mr. Chakravarti, what we'll do is we'll fix it on 16th of May.
16th.
You're not available or 12th of May,
No, I'm available.
16th of May. Heard Mr. S. Chakravarti, learned counsel for the writ petitioner. Also heard Miss S.
S.
Chakravarti,
Chakraborty.
learned counsel appearing for the respondent bank, who submits that during the pendency of this writ petition, the dues payable to the petitioner has been deposited in his bank account. Full stop.
He told you.
That's his her submission. Mr. Suman Chakravarti, learned counsel for the petitioner, prays for 2 weeks' time to seek instruction in the matter from his client. Prayer allowed. On the request of learned counsel for both the sides, this writ petition is directed to be posted again on 16/5.
12th, my lord, 12th May.
12/5/2023 as a fixed date.
Highly object. Item 6.
Lordship, I'm praying for further 4 weeks time, Lordship. I have not yet received the instruction, Lordship.
What is this matter about?
No, matter about my lord, non-payment of the benefit of MSCP, my lord, financial benefit, my lord. My lord, petitioner, my lord, generally declared, my lord, because he had already completed, my lord, 20 years of service, my lord, and 20 years of service, my lord, grants him, my lord, two, my lord, benefit, my lord, two financial upgradation, my lord. Instead of 2, my lord, he has get only 1, my lord.
What is the instruction you are seeking?
Lordship, I
This
have
is
not,
of December 2022.
yes, Lordship, I know,
So
Lordship, yes.
4 months, they have not been able to give instruction whether he is entitled to the MSCP and why it has not been paid.
Lordship, today, earlier also I have asked them for reminder. Today also they have sent one reminder again, Lordship, from here, Lordship. But I'm praying for further 4 weeks time, Lordship. Here his grade was, he is seeking that his grade should be reviewed from good to very good so that he get the benefit of second MSCP's, Lordship. So all those things are necessary.
That's what I'm asking. 4 weeks, 4 months have gone and this small point, they're not being.
In fact, Lordship, they generally sends the parawise comments so that a written document, written affidavit should be filed, Lordship. And this case, and generally I
All right,
file it.
we'll give you time till 26th of May.
Lordship,
On that day, if the instruction is not given, we'll pass an order that it will
Lordship,
carry
My lord.
interest. As if the MSCP is directed, it will carry interest at the rate of 12%.
My
With effect from the date on which it was due, and it will be recovered, the interest component will be recovered from the erring officials. But 26th is the last date
Lordship.
for you to come up clean. Heard Mr. S. Hawk, learned counsel for the petitioner, also heard Ms. B. Sharma, learned CGC, appearing for the respondent, who prays for further 4 weeks' time to obtain instruction and file affidavit in this matter, responding to the allegations made in the writ petition. Full stop. Although it is not understood as to why instruction on a small issue involved in this case could not be furnished to the learned CGC till today. Yet, on the request of Ms. Sharma, time is granted till 26/5/2023 to obtain instruction.
Obliged.
The date was 26th May. 26th. Obliged, ma'am.
Item 7.
Also, petitioner is a specially able person and he was selected in district selection committee HCL number 1. Thereafter, they have not appointed the petitioner. Thereafter, petitioner has approached this honorable court and they have filed an speaking order stating that they have made this state list from the district list and the vacancy position has been shown as 1 in case of LDA and 2 for grade 4. Thereafter, Lordship, I have challenged the death notification speaking order.
Acha, just a minute, Mr. Majumdar, can we? You see, I have seen that there are a large number of cases in compassionate appointment which are coming, and these are second round, third round, fourth round. And sometimes I find that orders of the coordinate benches are being shown. There is no clarity. In some cases, the courts are being lenient. Applications filed after 5 years, 8 years. 96, somebody dies. Even now, there are petitions filed for compassionate appointments.
I'm aware of.
There is no clarity in anything. No, what is this happening? Why doesn't the government advocate's office, it makes a request to club all these matters category wise? If a restatement of law is required, we'll do it. We'll do it, but otherwise, what do we do? Every time a case comes, we have to issue notice. These matters are being piled up. The persons, the litigants are waiting, looking at the sky that they will get some order someday. Orders are being passed here, sometimes not complied, sometimes complied, sometimes contempt. Contempt also sometimes the correct position is projected, sometimes it is not projected. So a time has come when we should go away with this kind of process. I'm on the process, not on the order. I am not commenting on the orders passed by any court. I am only on the procedure we are adopting in dealing with these matters. Don't you think a much better and transparent procedure can be adopted?
Hello, if your lordship permits me, I will go with the second part. There is some problem with the orders also. What is happening, my lord, what is happening is in some cases, I'm aware of it, my lord. In some cases where they are not entitled to any order, still an order is passed for considering. So that gives, my lord, that emboldens others who are waiting in the fence to file fresh cases.
So then why
That
these
is
things
the-
are not pointed out before the court? This court is
As a lawyer,
repeatedly
ma'am,
saying
you-
that-
Lordship will excuse me, as a lawyer, my friends on this side, they can only say that, see, he doesn't come within the parameters. If yet an order is passed for consideration.
No, but a counsel can always say that, please record my submission. As any honorable judge.
I'm
has ever
aware,
refused to do
your
that.
lordship has understood why, what I'm indicating.
No, no,
This
but
is-
you see, Mr. Majumdar, it is not about this or that.
My-
We are interested in having a transparent, vibrant system of delivering justice. Nothing is more important than this.
My lord.
We need to focus on genuine cases and quickly pass orders while separating the grains from the chaff. What is the point in having a compassionate appointment writ petition coming in 23,
My lord.
where the person has died in 96, 98, 2000? How can it be done?
Absolutely, this is what I'm saying.
How
Some-
can it be
Some
done?
cases orders have been passed to still consider,
And that's what we are facing.
despite being pointed out.
I have been
clearly.
shown orders from here, shown orders from there.
It is-
So if there are conflicting orders,
My lord, this
the
has to be
law
streamlined.
prescribes the way forward, then it has to be referred to a larger
My-
bench.
my
It
lord,
has to be referred
when
to a
a-
larger
when
bench.
a question of law or a point of law is decided, then
No, but nobody is coming up with this in a concerted manner. Even the
Well, we'll
government is
take-
not coming
I
up.
understand, we'll take care.
If
of
that
it.
is your plea, that conflicting orders are coming, it can happen.
Not really conflicting, well, but the word consider is creating difficulty for the
Then
department.
you raise this plea. If
Well-
this is to be considered by a larger bench, let it be considered.
Or we prefer an appeal again,
course.
one of these.
Any consideration must be preceded.
My lord,
This is of course my view as a judge,
absolutely.
by at least 2 sentences on if this consideration is found to be correct,
My lord,
then he will be entitled to the relief.
absolutely.
If he is not entitled to the relief, where is the question of consideration?
We'll take care. My lord.
This is
We'll-
only
we'll-
nothing but a disposal of a case,
My lord, we'll do
the
it.
disposal figures, nothing else.
My lord, we'll do it. In one
Each
case, at
case
least.
disposed of in hurry,
My lord.
generating 5, 6 more
Yes,
litigations.
yes. this is what I'm
Second
saying.
round, third round, then
Yes.
contempt, then again. What is the point in having this kind of matters?
True.
It is
In
not,
one-
it
in
is
one
not
case-
helping anybody,
My-
not the litigants, not the government, not the court process, nothing, no one. There should be more clarity on what is happening. If he is entitled, then an order should be such that it must be complied with.
And I'll just go. through
Otherwise,
the-
what is the point in passing an order?
I'll just go through the.
Each
orders.
order is
In one
generating
case,
3,
I'll
4
see that-
subsequent writ petitions and
I
4,
understand.
5 contempts. So you
My lord,
you are a very senior level officer of the
my lord,
government. You
I-
must bring these things to the notice of the court in an appropriate manner, which is permissible under the law and under the process, not by making ad hoc criticism of this or that.
my-
Let us resolve it. Maybe the learned judges are also not aware of what is happening.
I'll
It
see
has
that
to be
in one
brought
case,
before the court.
an appeal is filed against an order.
Bring it out. If it requires correction, let it be corrected.
My-
If it is not something to be corrected, then let it proceed. But it can't go on default. Just see the number. Do you know the number of cases which are piled up only on compassionate appointment?
Yeah, unfortunately.
Huh?
I'll take care.
Where is the compassion in the whole process? Tell me. I see everything else but compassion.
Except.
And in the name of compassionate appointment,
Everything
everything
else
else but compassion is
Yes.
happening. Yes, Mr. Singh.
Lordship,
That's all I wanted to.
My lord.
Page 17, Lordship. 17A. Lordship, a petitioner has been selected by the selection board for
No, First
Gwalpara.
of all, please tell me, what was the date of his appointment?
No, appointment.
Application.
It is a continuous.
I'll hear you. Please take your seat.
It is selection procedure of 2005.
Yes.
Lordship, thereafter petitioner has approached his honorable court for not giving appointment. That's serial number 1, Lordship. And this court has directed to consider his case for appointment. Thereafter, they have passed a speaking order that the vacancy position for heirloom and textile has been corrected and vacancy position for LDA has been modified to 1 and for grade 4 it is 4. That order was challenged before this honorable court again. After that, Lordship, that was set aside and this court has allowed to consider his case afresh. And thereafter, Lordship, same speaking order has been passed by the authority stating that the vacancy position has been corrected and now vacancy position is again 1 for LDA and 2 for grade 4. That is why, Lordship, the contempt petition filed by the petitioner has been closed by this honorable court, stating that this speaking order, you may go for challenging the speaking order. I have collected the copy of the application, Lordship, where they have appointed the person appointed from the select list, where it is reflected as per compliance with the order, page 59. Before that, Lordship can see page 47, the speaking order. Page 59.
What do you want to show? 47 or 59? You are saying
Page,
both.
initially 47, that will be
What
better.
do you want to first show?
They have shown that
Which is the page you want to place first?
page 47.
And then say that, yes.
Third paragraph, Lordship. Whereas petitioner Kirtimon appeared into against grade 3 post and head in textile department, Golpara district, recruitment held in Maniman. The name of the Kirtimon is serial number 1 of the district list prepared by the district Handloom Textile Department initially announced 7 number of posts at grade 4. 18 number of grade 3 posts. But subsequently, backlog vacancy position has been corrected by Director of Social Welfare and available vacancy has been only 1 grade 3 and 3 grade 4 posts.
Yes.
Because of this, Lordship, my contempt petition was closed with an observation that I may go for challenging the speaking order. That order, Lordship, will find at page 52. That order is passed on 16/12/2022. Page 52.
Page 52.
Page 52.
Yes.
Closing the contempt petition, however, shall be preclude the petitioner to challenge the order speaking the date 22/6/2022 if petitioner is otherwise entitled as per law. Now I'll take your Lordship to the
Yes, now, just a minute. What do you wanted to say? Mr.
But we have not filed affidavit, Lordship directed us, but I have forgotten to it. They have filed an affidavit. We will also file an affidavit shortly by day after tomorrow or on Monday. Let that matter maybe.
You are appearing for whom?
I am for social welfare department. Actually, this department, petitioner's case is all in this is bifurcated social welfare department earlier. Now it is social justice and employment. This is under empowerment. So standing council is there. Even down my I will file affidavit. Instruction has been sent to me. So I will file affidavit within short period of time. Then matter will be taken up for
I
here.
have no objection to that. Before that, kindly Lordship see page 59.
But the order I will pass.
No.
So
Only
also
thing is,
for
Lordship,
filing
only
affidavit.
thing is, Lordship, in the contempt proceeding also earlier occasion, this honorable court, before closing the contempt petition, this court has directed the authority to produce
What
the
is the order you want today?
Lordship, along with the affidavit, they produce the record of appointment.
Say that, say that. Produce the record. When will you file it?
Regarding appointment, Lordship, in compliance with
By Monday, I will file it. Within Monday.
By Monday.
Monday, they will file it. Thereafter, Lordship will list it matter, Lordship. We will also file a reply, Lordship.
Yes. After 2 weeks.
Mr. S.K. Goswami and counsel for the petitioner is present. Mr. R. Dhol and its standing counsel, Handloom and Textile Department, Assam, appearing for the respond numbers 3 and 4, submit that affidavit on behalf of his client has already been filed. Mr. Institutial and its additional senior government advocate, Assam, appearing for respond numbers 1 and 2, submit that he has also received instructions. And the same will be placed on record in the form of an affidavit on or before 2nd May 2023. In view of the nature of issue involved in this proceeding, I am inclined to grant time to the respondent numbers 1 and 2 to file affidavit as prayed for. Let this matter be listed again on 10th of May 2023 by tagging the affidavit with the records of this case. The petitioner may also file rejoinder in the meantime, if so advised. If you want to file rejoinder, if
Lordship, only thing is, Lordship, let him produce the record also.
the learned
Regarding appointment made in
Department of
Encompass order.
Council to also produce the records.
Regarding appointment made.
No, but if the affidavit is there, we'll decide it on the basis.
Yes,
of
yes,
that.
record, but it
Lordship,
may be difficult. Your department, earlier department is bifurcated. Now social.
So let him file the affidavit.
That is not the question, Lordship. No. Question is now, Handyman Textile said by filing an affidavit last occasion, stating that I have enclosed a list, whom they were appointed after the Lordship, the order passed by the Honorable Court. That has been disputed by them.
Mr.
So that is record is
We'll
necessary.
see, we'll see. Let him file the affidavit. He may not say anything adverse to your client's interest. Let us see what happens. We'll handle.
Because we have to file an, I have already filed.
I will come in argument. Item 9, Parter matter.
We'll take it up just now. You want to go just now?
My lord, the matter is only called. I'll just come back.
May I please? Mulad, last order, Mulad, dated Mulad 16/2/23. It says, Mulad, the DLC has recommended my name. That may be placed, Mulad, before the SLC now. So partly, Mulad, complied with, Mulad.
The direction was to the DLC to consider his case. DLC has now considered, so it will follow subsequently.
DLC is considered.
Yes.
Let it be placed before the Mulad SLC. That must.
So the direction.
All right, heard Mr. M. Mandi, learned counsel for the petitioner, also heard Mr. D. Nath, learned counsel appearing for the respondents. For the respondents who submit that in terms of the order dated, what is the date of the order?
16/2/23.
No, the order of the court,
Yes.
order dated 31/2017. Passed by this court in WPC number 513/2017. The case of the petitioner has been considered by the DLC. And now the matter would be forwarded to the SLC for due consideration.
The concerned department will do, Malab, because this is the chairman of the DLC only.
Now the matter will be forwarded by the concerned department for consideration by the SLC. Full stop. Now, as such, Mr. Nath submits that the order of this court has already been complied with. Mr. You are there?
Lordship, I am for appearing on behalf of Deva Sharma Lordship without.
Respond
The
number?
present
Number 1, Lordship.
Mr. R. K. Talukdar, learned counsel is present on behalf of respond number 1. You have 4 respond numbers?
The earlier deputy commissioner, Malab,
Respondent number,
he's the next respondent, Malab.
Mr. Nath, the respond number 2. If that be so, nothing survives in this content case. Mr. Mondal has also agreed to the said proposition. In view of the above, this contempt case stands closed.
I may be permitted to, Mulad, punish the order before the Mulad SLC, Mulad. Otherwise,
You go and do
it
it.
will.
There is no order to be.
Yes.
Next matter, please.
For hearing, I didn't say.
9, I have come back. Okay.
Hey, please, your lordship. Lordship, in this matter, my senior Mr. S.K. Medi appears for Accountant General. Today, he is out of station, lordship.
Can't help it.
Accountant general has
But
no role, my.
AG has got very limited role.
No, but can we close it without hearing him?
Yes. Yes.
You agree that we can pass a final order without hearing your counsel, your
Actually, he
Well,
has
they
been-
are-
only for clarification, he has been implemented by this honorable court.
Mr. Ghosh.
And
Mr.
AG has
Madana,
no role.
all I am saying that, can we say that AG has no role? So although
Yes,
AG
yes.
has been made party.
Yes,
Fine.
yes.
Huh?
My lord.
So of course not. Why have you made party then, AG?
My lord,
You can't make party someone and tell the
No,
court
no,
that.
why
that
it
person
has
is-
been made party, my lord, on last occasion,
your lordship wants some comment on the part of AG regarding pay fixation matter. So that is why he has been implemented to clarify the court about the fixation. Otherwise, AG has no role in this case.
So there is an order of this court.
Yes, yes.
Which is the order by which AG has been,
Well, there is an order of 14th of February 23, man. The third paragraph from the bottom says the issues involved in the retribution relates to intricate question of pay fixation and pay parity with reference to the fitment table. This court is of the opinion that the Accountant General ANE Assam should be heard before final decision is taken in the matter.
Mr. Majumdar, after hearing you and Mr. Ghosh, can the court say that there is no need to hear the AG?
After this order of
That's what I'm asking. Why are you making this a submission?
otherwise, my lord, the final order of pay, they have the respondent hearing approached the Assam Administrative Tribunal challenging an order passed by the government whereby she was refused the stepping up of pay. And for stepping up of pay, ultimately the order has to be passed by the Administrative Department of the state. So that way AG directly is not involved. Once it is granted, then AG may come in. So possibly your lordship can decide.
No, you
But
know
then-
about a concept now. There is
No, but
something
you-
called pre-waiting. Now this concept is coming in India in a big manner, in
Well-
taxation law,
My lord,
many other law, even in yesterday, if you look at the media,
my lord.
suggestions have come that even in matters of constitutional amendments, etc.,
My lord.
the time has come when there is some pre-waiting opinion is taken. Right? The idea is after the order is passed, instead of having 10 litigations here and there, why don't you have the opinion of the concerned authority? Once the order is passed and if it is in the process of implementation, the AG will definitely have a role to play. So instead of deferring the litigation to that stage, why not have the AG right now on board?
And
have a view.
matter of 10-15 days.
Yes. So
It will be-
therefore, this order was passed. Now
Right.
today he is saying Mr. Mehdi is by name again engaged. So
I'll leave it to your lordship. I am otherwise ready.
I will not pass a final order without hearing Mr.
Then,
Mehdi.
then,
You
then,
can argue.
then the case will fix on a date when they
If
are.
he says he has nothing to submit, then it's fine.
Then,
Is that what his stand is? He won't be able to say.
no, he's simply saying that his senior Mr. Mehdi is today out of station.
Does Mr. Mehdi have anything to say here?
He told me to pray before this honorable court that matter may be taken on another day.
When is your senior coming back?
On 27.
Day after tomorrow?
Yes, Lordship.
We have it day after tomorrow
No.
then? Huh?
I have no.
Mr. D. Majumdar and senior counsel is present on behalf of the petitioner. Mr. D. Ghosh, learned counsel is representing the respondent number one. Mr. Your name, please?
KK Medhi.
Mr. KK Medhi has appeared on behalf of Mr. SK Medhi, Learned CGC, and seeks posting of this matter again on 27/4/2023 on the ground that his senior is out of station. Full stop. Considering the fact that in view of the order dated 14/2/2023 passed by this court, the prayer made by Mr. Medhi cannot be ignored by this court at this stage. As such, as agreed to by learned counsel for all the parties, registered to release this matter again on 27/4/2023 as a fixed item. Mr. Majumdar, we need to innovate at times. These matters are already quite old matters. So passing an order in this technical nature of issues, always it is a better idea to onboard all
Yes.
authorities who will have a role to play. So
Ultimately.
that if there is something genuine which needs to be address.
Or two minutes.
This, a stitch in time saves 9.
Concessional line.
That is the
Yes, yes.
concept here. So what is the tearing hurry? If it is,
Yes.
would wait for so long, let it wait for another 2 days.
Or instead of 27, he says he would be coming back on 27. Let it be on second.
He will be coming on 26 to Guwahati.
All I don't know, you agree on a date,
Second. May.
2nd May.
Second.
All right.
Second May, I would be out.
Then third.
Third. Third.
Third.
Oh, third.
But actually, I'm of the report saying AG's role only come after retirement.
Anyway, once your lordship is passed in
You
order.
have not heard what I am saying.
Yes.
You are
Yes, I-
only stuck up with something
Yes,
you
yes.
know.
No.
I am saying I want to know the AG's views in advance. These are called pre-wetting orders.
Yes.
That I
You must not have
that I
heard
have
about this
understood.
concept.
That I have
Then
understood.
why are you again and again
No,
saying
that
something?
is, I'm saying that.
I know AG's role comes later,
After.
but is the court not entitled to get the view of AG in
Yes,
advance?
yes, it
Huh?
can be.
That is why the order, you have not read the order 14.2.
Let it be.
Read the order 14.2 once. Do
No,
you have
I-
it? Read it once.
On that day also, that
Huh?
is why AG has been impleted.
We'll do it in the manner we think is proper. Doesn't matter. If the AG doesn't have a view to, then we'll put it on record. That's all. What is the harm in hearing the AG once? They are the final, you see, accountants of the country.
Your lordship is correct, because although the final order will be passed by the government, but the AG has a role actually. Because ultimately,
Hmm.
in some cases, yesterday I was looking into some cases, they say that AG also needs to be finally given a chance.
Of course, I think so, because this will save number of litigations.
Because in one case I have seen, unless AG says so, so AG's role. to some
Not that AG can sit over appeal over High Court order,
Yes.
but then what is the problem in passing an order which
In their
meets all the
business.
requirement? What is the problem? Yes.
But
Third man.
May I please, your lordship?
Yes.
Lordship, this case was part heard. But
Mhm.
should we continue from there or from the start?
What is the case? Let us
Yes,
see.
your lordship. What happened in this case is that petitioner was flying a commercial vehicle and Indica car as hired taxi with due permit. Vehicle was registered as a commercial vehicle. White number AS01AA 5744. The vehicle was duly insured by policy number this. The said vehicle was operated by a driver and used to park at Patan Bazaar near railway station to ply on demand. As like other day on 14/10/2006, vehicle was taken by the driver. Since that day, the vehicle was out on the day and it did not came back. The vehicle and the driver has been missing since that day, and the petitioner has searched the vehicle on his level. And on 18/10/2006, he has lodged an FIR with OC Patan Bazaar PS, where there is a case registered under section 392 and 342 of the IPC. But Patan Bazaar PS case number this. But the Patan Bazaar PS, unable to find any clue, submitted the final report in the case. Then the petitioner has claimed to have the insurance amount, but the insurer has repudiated the to pay the insured amount, stating that it is a case of criminal breach of trust by the employee of the petitioner. Then the petitioner has approached the insurance ombudsman, but the learned ombudsman has dismissed petitioner's claim and depriving the petitioner from its rights. And after that, the petitioner approached the honorable court, your lordship. Shall I, lordship?
Where is the order of the insurance ombudsman?
There are two orders, your lordship.
Hmm.
Will take you to the first one is the annexure number 6, your lordship, page number 21, your lordship.
Page number?
21, your lordship.
Yes.
Yes, your lordship. This is the ombudsman order dated 13/1/2012, your lordship, whereby the ombudsman had directed the respondent to pay the insurance amount, your lordship. And then, your lordship, we made the representation and attached this order and sent to the insurance company, and then they appeared before the ombudsman, and then a second order was passed. That is annexure number 7, your lordship. That is on page number 23, your lordship. That is of dated 3rd September 2013. In this order, my claim was repudiated, your lordship. Lordship, as per this and as per the affidavit and opposition, they had given 3 grounds for repudiation of my claim, your lordship. Lordship, could you find this, the affidavit and opposition?
1 minute.
Yes, sir. Lord.
And where is the second order?
The second order is page number 23, your lordship. That is annexure number 7, your lordship. This order is dated of 3rd September 2013. The decision made is on page number 25, your lordship. Which continues to 26 and 27, 28, your lordship.
Where is the letter repudiating the claim?
Yes, your lordship. That is lordship, technically.
Page number?
Sir. Claim was not repudiated. We came to know about the repudiation after this second order, your lordship.
But
It was
there-
never
there is no-
intimidated.
There is
Never
no
intimidated.
letter.
Never.
And where is clause 7, condition 7?
Lordship, I have provided a copy, lordship, of the commercial policy, lordship. Because they should be providing the policy because it is they're good at it, your lordship. Still, I have find this out from the internet, your lordship, and placed a copy before your lordship. Lordship, I shall take you to fifth page, your lordship. On the second, for your lordship, second para. Shall I read that portion, your lordship?
1 minute.
I have highlighted the portion, your lordship.
Yes.
Lordship, they had the date of reputation was decided and intimated to the petitioner on 19/10/2012, your lordship. After receiving the representation dated 9 February 2012, along with a copy of order dated 13/1/2012. Now the order dated 13/1/2012 is the first order by the passed by the ombudsman, your lordship. Now, lordship, I have highlighted the portion. It is also, shall I read it or only? It is also hereby further expressly agreed and declared that if the company shall disclaim liability to the insured for any claim hereunder, and such claim shall not, within 12 calendar months from the date of such disclaimer, have been made the subject matter of a suit in a court of law, then the claim shall for all purposes be deemed to have been abandoned and shall not thereafter be recoverable hereunder. Now, your lordship, the date of repudiation was intimated to me on 19th October 2012, and prior to that, I had already approached the ombudsman, ombudsman, and they had passed the order directing them to pay my insurance. So, as the insurance ombudsman is a quasi-judicial body, I had intimidated to the judicial body.
No, where
So
is where is the letter by which they had repudiated your claim? The repudiation of the claim is where? Is there any communication, Ms. Majumdar?
No, that's why actually we had submitted all the documents before the ombudsman. And lordship by one order asked the ombudsman to send the records. But they have said that as per legal provision, they have destroyed the record. But in the order itself, it is there, and what they are submitting, I have the list of dates with me, not there.
No, but have you informed the insurer?
It's,
Insured?
and they
Where
had,
is that letter?
that letter we had submitted before the ombudsman. Lordship. That's
You
why-
don't have a copy, office copy is not there.
No, lordship, we do not have, and that was the problem, lordship, because lordship, what happened? Theft was on 14/10/6. Report of theft to police was on 18/10/6. And report to insurance company was on 26/10/06.
Yes.
No claim was intimated to him on 31/7/07. And the first case he went to, that request for reconsideration, he went to the ombudsman. Sorry, request for reconsideration, he gave a letter on 26/3/2010.
Where is that letter?
That letter. No, they are any-
Is it a part of the record?
Yes, they have submitted lordship, that is annexer 3 lordship. Here it is, date is given as 4/8/2010,
Page number?
page 15 lordship. I think that letter dated 26/3/10, he has not annexed here. But this letter is there, lordship, 4/10, 4/8/10. So lordship. After this letter, lordship, another letter maybe was given, because in the judgment of ombudsman, it is mentioned 26/3/10. One letter, lordship, page 26.
So now the vehicle was insured.
Yes,
Then why aren't you considering the claim?
lordship, because of lordship, this clause 7, lordship. Clause
Where is the clause 7?
clause 7, she has given the commercial, she just now read. She might have given a bunch of
Do you have the
You
clause
have-
7? Do you have it?
Lordship, you have a copy of it, you know.
These things you should give
Lordship-
on record in a
Lordship,
proper
this-
format with us. Please read clause 7.
Yes, lordship, clause 7, beginning is not relevant here, lordship. That lordship will come to last para of clause 7. It is also here. It will. No, okay. I'll read lordship. No, to printing or product, no problem. It is also hereby further expressly agreed and declared that if the company shall disclaim liability to the insured for any claim hereunder, and such claim shall not, within 12 calendar months from the date of such disclaimer, have been made the subject matter of a suit in a court of law, then the claim shall, for all purposes, be deemed to have been abandoned and shall not thereafter be recoverable hereunder. This is because, lordship, his no claim intimation was given to him in 2007 itself, July.
Where is that document?
That's what, lordship, that was destroyed before the ombudsman, lordship, but in the judgment it is mentioned.
No, where is the judgment mentioned about any particular letter, document?
Yes, lordship.
Where is it?
Lordship, lordship will come to. Lordship will come to page 26 of their writ petition, lordship.
Yes.
26. This first, second, lordship, third, but it starts with, it appears from the self-contained note as well as from the statement of.
So condition 7 says first, the the insurance company has to reject or repudiate the claim.
Hmm.
Then if within
No claim.
12 calendar months, no proceeding is initiated in a court of law, then it will stand closed forever.
Hmm.
So to invoke clause 7, first you have to show that on this date, you had disclaimed or you have issued a disclaimer that your claim will not be entertained. Where is the document? If the
Lordship,
document
it
is not
was-
there, clause 7 will not be applicable.
No, Lordship, it was submitted before the ombudsman.
No, but
Because,
it has to be given to the insurer.
no, to him also it was given. He has not annexed, the petitioner has not annexed it.
Did you receive it?
No,
Because he has not annexed even before the ombudsman, because the first order, Lordship, there he has not even disclosed about this, because that petition was filed, Lordship, on 4/8/2011. And this letter also is of 26/3/10, Lordship, for reconsideration, Lordship. That letter,
There is
he does
nothing
not-
in the law, order of the ombudsman which says there was a letter issued of disclaimer. Where is that observation in the order of the ombudsman? It
Lordship,
could be a
this-
office self-contained note, they say it appears.
Yes, self-contained note means this is the something like a written statement that the insurance company had presented before the ombudsman with all the relevant documents, Lordship. That is what is the.
Sorry, can't accept it. You have to show me that letter, it was issued to the insured saying that, look here, we are repudiating your claim. And from that date, if 12 months time has gone and the proceedings have not been issued, we will close the matter. Otherwise, this matter cannot be closed.
Lordship, the problem is those were, as per the judgment itself, those were submitted before the, and Lordship.
Where is that part in the judgment? Where is it?
Lordship, this paragraph, I'll read.
Yes, yes.
It appears from the self-contained note as well as from the statement of the representative of the insurer that the complainant, Mr. Judge Charan Burman, made request for consideration of his claim without submission of document on 26/3/2010, that is after 2 years, 7 months, which attracts the policy condition number 7. The insurer had produced the copy of request letter dated 26/3/10 of the complainant and the terms and condition of the policy before this authority, which are marked as Annexure J and Annexure L respectively. On perusal of Annexure J, it is clear that the complainant could not submit all the claim papers before the insurer due to non-receipt of police final report. On a close perusal of the Annexure L, it is clearly mentioned in condition 7 of the policy terms and conditions that the company shall disclaim liability to the insured for any claim hereunder, and such claim shall not within 12 calendar months from the date of such disclaimer have been made of a suit in a court of law. Then the claim shall for all purposes be deemed to have been abandoned and shall not therefore be recoverable hereunder. So Lordship, those documents were submitted there, Lordship.
And where is this criminal breach of trust? Where is that
No,
condition?
that our High Court judgment is there, Lordship. On the other two grounds, Lordship, that documents were not submitted because he gave an explanation. But that explanation also came very late, but still, Lordship, but only this clause 7, Lordship, that
So
abandoned.
originally the ground were clause 7, then explanation came late and criminal breach of trust by the driver.
Yes, but our High Court judgment is there, Lordship, on criminal breach of trust, that this won't be criminal breach of trust. So I'm not touching on that, but this part that no claim intimation was made to him on 31/7/2007 itself.
Hmm.
And his reconsideration came in 26/3/10, and then his petition.
What happened on 31/7/2007?
That letter was sent to him that since he did not submit the documents, so his claim is termed as.
Where is that letter? That's what I'm saying.
Yes, Lordship, that letter. I can again try, Lordship, with the insurance company.
We are closing this matter today.
Lordship, but the thing is, Lordship, in a case where the insurance company cannot pay, Lordship, if Lordship directs them to pay the amount, that will be, I think, it will be beyond the policy condition, Lordship.
That we'll decide. You challenge it if you are unhappy. Because the only question is whether clause 7, condition 7 will be applicable here.
Hmm.
Condition 7 will be applicable if you have issued a clear repudiation of the claim notice saying that for this reason we are closing the matter. And then within 12 months, no proceeding is initiated. Then clause 7 will come in. Then it will be within the realm of the condition of contract. But
Lordship, then
merely
Lordship,
because merely because of the observation and the ombudsman order.
No,
First of
because
all,
the
this-
documents were there, Lordship. Then Lordship,
No, no,
I.
listen. First of all, this observation which I'll quote in the order does not indicate that there was a proper repudiation of claim. It could be the sense flowing from your statement, which is the self-contained note. And secondly, even if this is the procedure, it will not be proper. You have to inform the insured
No, that
that
was-
your claim is being repudiated.
No,
Where
no.
is that order? Where is
No,
that?
Lordship, let me take Lordship to page number 15 of their writ petition, Lordship, Annex 3. Here he mentions in the last fourth paragraph, Lordship. Your branch office had reported me by their letter dated 11/7/07 to submit the final report in police investigation report along with the vehicular documents within 5 days on receipt of the letter. But due to so Lordship, that correspondence was there, which is, he is not revealing that
So
correspondence.
you are telling that the court should presume that it was informed.
No,
And on such presumption,
No, I'm
then-
not asking about presumption, Lordship. Those documents were submitted before the ombudsman.
Which is the document? Which is that document?
That no claim
What is the
intimation.
particulars of that document? You tell me. What is the
Lordship-
date of that document, number of that document? You tell me.
No, date
I am
is,
saying that even if you have done it, even then we will not accept it. But at least show that this document was there before the tribunal. As a proof that the claim was repudiated.
Lordship, then I'll request for a short date, Lordship.
Just one thing to say.
No, I am releasing this matter from Pathak. You are
Lordship,
disturbing the course of the.
Kindly come to the
No.
affidavit.
Heard Ms. Kidas, Learned Counsel for the petitioner, also heard Ms. R.D. Mazumdar, Learned Standing Counsel Insurance Company, appearing for the respondents who seeks further 10 days time to obtain instruction in the matter. So this is a matter pertaining to bench 4 and it has been civil bench 4 and has been repeatedly adjourned. This petition stands released from Pathak. This matter again after 2 weeks before the appropriate bench.
Lordship may be fixed by.
Never disturb the court when I'm hearing a matter.
Maybe fixed by a date. your
Now you
lordship.
try it out somewhere. All right. This is a basic courtesy you young lawyers must know. I'm interacting with you. Why are you disturbing the court?
Lordship, in the affidavit.
When
of
I want to
opposition,
know something from you, I will ask you.
They had given the date, your lordship.
This is over in this court. You try somewhere else.
Leave your discussion.
Yes.
My lord, here is a case of termination of service of a person who was serving in the border security force on the ground that he was he had overstayed his leave, his sanctioned leave. My lord, prior to his termination from service, they had held a court of inquiry. This court of inquiry is required to be held according to the procedure laid down in the BSF rules 173(8), which gives the person the right to cross-examine any of the witnesses, to know what is against him, and to do everything before the court comes to an opinion regarding his guilt or otherwise. No matter the stand in the affidavit in opposition to my data assertion is that since he was absent, he need not be given any opportunity. This has been held to be wrong by this honorable court in other judgments. Therefore, that is the case.
Mr. Manunda,
My
just take a seat for a minute.
My lord.
Yes.
The petitioner, he joined his services in the border security force in the year 2004. In the year 2009, he was granted 15 days casual leave. Number when he did not return back because of his medical problems, a notice was sent to him saying that a court of inquiry had been held and he was required to show cause why he should not be dismissed. His condition, my lord, deteriorated. He did not reply to it. And thereafter, the commandant of the battalion passed an order terminating his services. He filed an appeal putting forward all his medical documents and everything. And his appeal was also thereafter dismissed. Now, if Lordship would kindly have the notice that I had first received at page 14, my lord.
Page 14,
Page 14, my lord.
yes.
Now, it is to so and so dated 18th of September 2009. Subject show cause notice. Based on the report available, it is noted that you have been illegally and without sufficient cause overstaying leave with effect from 26/2009 afternoon. The proceedings of the Court of Inquiry held in accordance with Section 62 of the BSF Act to investigate into the said illegal absence has also found and declared that you have been illegally without sufficient cause overstaying leave. Having considered the matter of your said continued illegal absence from duty, I am satisfied that your trial by a security force court is not only inexpedient, but also impracticable, and that your further retention in the service is undesirable. Accordingly, in exercise of power vested by me in me by subsection 2 of section 2 of 11 of the BSF Act, read with rule 177 of the BSF rules, and in conformity with sub-rule 2 of rule 22 of the BSF rules, you are hereby called upon to show cause as to why you should not be dismissed from service for your aforesaid act. If you have anything to urge in your defense against the proposed dismissal from service, you may do so within 30 days of issue of this notice, failing which it will be assumed that you have nothing to urge in your defense. This was the notice received by me. Lordship will find on the next page. These are the type copies. It will be easier to refer to the originals, my lord, which start at page 25. At page 25 is the forwarding of the Court of Inquiry proceedings. At page 27, Lordship will find the order by which the Court of Inquiry was convened. Page 27, I'm referring, my lord.
Yes.
As approved by the commandant, Shri so-and-so, the assistant commandant of this unit is hereby detailed to conduct a one-man court of inquiry to investigate into the circumstances under which force number so-and-so of this company, of this unit, is overstaying from leave with effect from 26/2009. The provisions of BSF Rule 173(8) of BSF Rule 1969 will be complied with wherever applicable. Now, may I draw Lordship's attention to 173(8), my lord. BSF extension.
So just a minute, before that, BSF rules.
Madam.
Where is the order of dismissal from
My lord,
service?
the order of dismissal, actually, I have made a statement. It was never served upon me. I was only informed that you have been terminated from services and therefore you should return back your ID card. Order of dismissal, they have given in their affidavit in opposition. Lordship will find that at page 64, running page 64, otherwise page 17 of the affidavit in opposition. I have examined the matter relating to without sufficient cause overstay of leave by number so-and-so as mandated by sub-rule 2 of rule 22 of the BSF rules. The same constable was given an opportunity to show cause by 27 Battalion BSF registered notice number dated 18 September 2009, which I just read, against his proposed dismissal from service. Number so-and-so, however, failed to submit any reply to the said show cause notice till date. Considering the matter in its entirety, I am satisfied that number so-and-so has been illegally and without sufficient cause overstaying leave since 20th of June 2009. I am also satisfied that his aforesaid continued illegal service is contrary to the expected norms and is detrimental to the force discipline, which makes his further retention in the force undesirable. I therefore directed the said so-and-so be dismissed from service with effect from 12/11/2009. The overstay period of 145 days is hereby treated as dias non. He has been struck off from strength of his unit with effect from 13/11, an amount of which 1087 on account of deficient kit clothing items were recovered from his undisbursed amount and deposited in the government treasury. Now, this notice of, this termination order is dependent on the notice dated 18th of
So
September.
did you
2000.
prefer an appeal against this
We
order?
preferred I preferred an appeal, my lord. In the appeal, they took only two grounds, my lord. One,
No, this appeal, you said that the order was never served, you got
it
it
was not
only,
served upon me. my lord.
only the counter affidavit in.
Yes, that is when.
Then you preferred an appeal without
Appeal,
knowing the order.
without knowing, my lord, I had preferred an appeal. They had given me a letter saying that if you have got anything on medical documents, you give it to us. I gave them all my medical documents. They rejected my appeal, saying that that their doctor does not think that the medical rest given in the medical prescriptions was necessary. Therefore, appeal
So
is
your
refused.
client had overstayed on the leave for 145 days.
My lord, yes.
What is the reason?
My lord, he was admitted just prior to the end of his leave period. He was admitted to the hospital, and thereafter he suffered from 3 different diseases in a running condition, my lord.
What are the 3?
My lord, that is given, my lord, here. Initially, it was malaria with hepatitis, my lord. And thereafter, my lord, he was diagnosed with sciatica and urinary tract infection. These 2 conditions, my lord, led him not to.
Where are the medical documents?
My lord, medical documents, all the medical documents had
No,
been.
here.
My lord, here I could not give because all the medical documents had been deposited with the respondents, which they did not have. All original documents given to them along with the appeal.
So what is now the ground on?
My lord, the entire termination of service depends on their court of inquiry. The court of inquiry, my lord, was required to give me certain safeguards. Admittedly, they admit in the affidavit of opposition that because of my absence, they did not even go to give me any opportunity of safeguard. No notice was even issued to me. This honorable court, in a very similar circumstances, my lord, has set aside that inquiry proceedings, set aside the termination, leaving it upon them to hold a de novo inquiry. Therefore, my lord, I was trying to draw lordship's attention to to rule 173(8), which the show cause which the convening order itself refers to. The convening order, my lord, I'll just read that one sentence again. Convening order, page 27, provision of BSF rule 173(8) of the BSF rule 1969 be complied with. Now 173(8), if lordship has 173, is the procedure for court of inquiry. 173(1). Proceedings of a court of inquiry shall not be open to public. 2. Evidence of all the witnesses shall be taken on oath or affirmation. Well, this part also I will show was not done by them. Evidence given by the witness shall be recorded in a narrative form. Court may take into consideration any document. Court may ask any witness any question. No counsel or legal petition shall be permitted. Provisions of section 89. This was also not followed while calling for the witnesses. The entire court of inquiry was done on a single day with 5 witnesses. While this clause requires that the witnesses have to be summoned by the court of inquiry, it was all done within the same day.
You have the records.
Yes. And para 8, if lordship will find the clause 8, before giving an opinion against any person subject to the act, the court will afford that person the opportunity to know all that has been stated against him, cross-examine any witness who have given evidence against him, and make a statement and call witnesses in his defense. Now, their affidavit in opposition, if lordship kindly has, at running page 56, they say during the court of inquiry, no opportunity was granted to me because it was being held in absentia. Now, other notices, my lord, I have received. Had I not responded to a notice from the court of inquiry that one is being held, kindly come and participate.
No notice was also issued.
Nothing was done. I never knew that there was a court of inquiry. If at page 56, if lordship will find paragraph 16 of their affidavit in opposition. Towards the bottom. That with regard to the statement made in paragraph 13 of the writ petition, the deponent begs to state that as per section 62 of the BSF Act 1968, when any person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall be constituted under section 62 of the BSF Act. It is pertinent to state here that in this inquiry, this inquiry is held in absentia, and question of applying rule 173(8) in an inquiry conducted under rule 62 does not apply to the instant case. But what had happened is this procedure was challenged in different high courts, even in the before the Jammu and Kashmir High Court, before other high courts also.
In 2010 came a judgment that without notice and without giving him an opportunity, the court of inquiry has to go. So in the year 2011, they amended the rules to incorporate a provision saying that persons being absent need not be given any notice of the court of inquiry. My inquiry was held in the year 2009. This aspect has been considered by this honorable court, my lord, in another petition where this honorable court had held that since it is prior to the amendment, therefore the inquiry proceedings held at that stage is wrong. It has to go back for a de novo inquiry at best. Otherwise, my lord, the way the witness was taken, the summoning of the witnesses, whether oath was there, whether affirmation was there, there are other grounds that I can proceed on. But on this ground, my lord, on this short ground, perhaps, if the court of inquiry is held to be bad, he will be given an opportunity of participating in a court of inquiry. That is after 10 years, my lord, of the alleged incident.
But reinstatement
Or-
will be difficult.
The
You can
reinstatement-
only ask them to conclude it within a time bound manner.
My lord,
After 10 years, suddenly reinstatement will be difficult.
my lord, that has been allowed by this court in different occasions, and my lord, lordship, he was here immediately when the appeal was dismissed. It was dismissed in the year 2011, and he came back here in the year 2012, my lord. He
There is
has
a
not been delayed
Practical
for a-
side of everything.
My lord,
There's a practical side to everything.
my
No?
lord, this aspect has also been considered by the honorable
Let-
Supreme Court in
Let us see. which
Deepa
way-
Kundu Survase case, my lord. I had provided, I'll provide the number, I'll just. And my lord, in the. By this honorable court also, my lord, there was the court is not passing any directions with regard to any of the consequential benefits. Sorry, the consequence of the same is that the dismissal order stands vitiated accordingly in view of the reasons stated above. Ordered, so issued by the respondent in dismissing the petitioner from services set aside along with any consequential orders, the petitioner shall accordingly be reinstated into service by the respondent.
Where is the word?
Yes, okay. You have to do that.
This is against BSF.
My lord, the same act, the same grounds 173(8) by this honorable court, my lord, in 2018.
Is it a covered matter? What has happened to this judgment?
There, my lord, he was terminated in 2008 and he was reinstated in 2019, my lord.
What has happened to this judgment? Have you implemented it? If you have implemented, you will have to do it here also.
That instruction.
Then you tell us. It's as simple as that. If you have not challenged this judgment and implemented it, you will have to do it here also. I'm making it very clear. We will have to maintain parity of. If this is a case where absentia inquiry was held, no notice, court set aside, directed reinstatement, you reinstated, implemented the orders, you will have to do it here also.
Yeah, then I.
How much time do you want for that? Day after tomorrow?
Excuse.
Mr. R. Majumdar, learned counsel for the petition, also heard Ms. B. Sharma, learned CGC, appearing for the respondents who seeks posting of this matter again on 2/5/2023, so as to enable her to obtain inspection as to whether the order dated. What is the date of this order?
The termination order, my lord.
No, this order, this type of.
18.
27/6/2018, my lord.
27/6/2018 passed by this court in the case of Satish Kumar, bracket, force number XSI/ministerial, you'll get it here, versus Union of India and others, in a similar case, has been implemented insofar as the reinstatement of the petitioner pursuant to setting aside the order of his dismissal for service is concerned. Full stop. Register to list the case accordingly. Let them tell us. If they have not preferred any appeal here, then if the facts are same, we'll pass the same order.
I'm obliged, my lord.
My pleasure, Lordship. My lord, the case of the petitioner is that, my lord, he was appointed as in Shima Suraksha Bal, my lord, and he was accorded punishment for some days, my lord.
You are appearing. Ready?
Thereafter, my lord, But which,
On the ticket, they are not here, if records are necessary, lots of records are not. Me lots of it's whether it's required or not. That is perhaps.
Records will be required.
record will be required because my lord, they said they have given me opportunity. But so far my petitioner concerned that my lord, no opportunity was given.
Then let the records be, when can you produce the records?
Has to come up from.
Wrong, yeah.
Mr. J.R. Borbia, learned counsel appearing for the writ petitioner submits that he is ready to argue the matter, but the records will be necessary for disposal of this writ petition. Ms. B. Sharma, learned CGC appearing for the respondents has also agreed to the said proposition, but 6, how much time?
It will come from Rangya, my lord.
Lordship, in a month of May, Lordship.
But 6 time till 18th of May 2023 to produce the record. In view of the request made by the learned CGC, this matter is directed to be listed for hearing as a fixed item on 18/5/2023. On the next date fixed, the records will be made available by the learned CGC.
Problem.
Item 30. My lord, in this case, record has been called for. I have received the record just now, my lord. They all are in Hindi, my lord. I have required some time to go through it, my lord. Next week, my lord. Any day.
Matter of 2015, my lord. Lordship's convenience.
Next week, my lord, like Tuesday.
16 May then. Mr. R. Majumdar, learned counsel is present on the other petitioner. Ms. A. Gayal, learned CGC submits that she has just received the record and therefore prays for some time to examine the same as the notings are all in, examine the same before making submission before this court. On the request of Ms. Gayan and as agreed to by the petitioner's counsel, let this matter be listed again as a fixed item on 16/5/2023.
Master.
For hearing. For hearing.
Yeah, please, Your Lordship. Lordship, here also we have received the record today morning, so some time may be granted to go through the records.
Lordship, kindly fix the matter on 4th of May, Lordship.
4th of May, then it has to go before another court. 4th of May will be difficult. Any other date?
Any other day, Lordship, any day, Lordship.
11th May.
Lordship.
Ms. R. Devi, learned counsel is present on behalf of the petitioner. Ms. L. Devi, learned CGC submits that the records have just been received by her and therefore 10 days time is required to examine the same. On the request of learned CGC, this writ petition is directed to be listed again on 11/5/2023 for hearing as a fixed item.
Obliged, Lordship.
Some prayer for adjournment was made.
My lord, the other side is necessary, my lord. Respondent number 4 is necessary because his promotion was challenged.
Mr. M.K. Sharma, learned counsel for the petitioner is present. Prayer for adjournment has been made on behalf of the respondent number 4 on the ground that the arguing counsel is out of station. Since the prayer is not opposed, so Mr. Nzala, let this matter be listed for hearing again after 2 weeks on a non-miscellaneous note.
Fine. All right.
Yes, Mr. Chair.
My lord, in item number 5, in the morning, Lordship granted me time till 12th of May to get the instruction as to whether my client got the money. Right now, just few minutes back, I got the instruction, he received that money. It has been credited in his account. So my lord, nothing survives in the writ petition, my lord.
We'll close it.
My lord, because our prayer was for a direction to pay him his leave encashment amount. And bank submitted that it was credited, but I was not aware of. And Lordship granted me till 12th of May to get that instruction. I had a talk with my client and he said that he.
Can you inform the bank's counsel?
I'll
You can close the-
inform and we'll come back at 2.
Hmm?
I'll inform her.
If there is no other matter. Tomorrow,
Tomorrow, my lord. Tomorrow.
then in item 5, you write on the same thing, list the matter tomorrow. That
Ma-
is so and so. Tomorrow we'll close it.
My lord. Instead of waiting till 12, my lord, it is better. It will be a disposal.
So any other matter, any part 2 hearing original list, anybody is ready? This is a hearing day, nobody is ready for hearing.